All right, Judge Sawaya is going to leave us now, and we're going to have Judge Edwards come in. And we will call the last case of the day, which is MADL versus Wells Fargo. Thank you, Ray. Morning, counsel.
Good morning, Your Honors. May it please the Court. Bo Bowen, Bowen Law Group on behalf of the MADLs, the appellants in this case, and the appellants are sitting here in the courtroom today. I'd like to reserve 10 minutes of my time for rebuttal.
All right.
If I happen to go over a few minutes. And it's my typical belief in cases that each case obviously should be weighed on the merits of its own case and the facts of that case. And I'm reluctant in most cases to point out or to reference what we all recall as the robo-signing scandal back in 2009. The only reason why I mentioned it in the brief here, and I think I would be remiss not to mention it here on argument, is I think to understand this case, you have to understand the context in which it arose. This is a case that was filed back in 2009 and has all the indicia of what we know as a robo-signing scandal. We have the same parties. We have Davis
There are three different versions of the note in terms of one with no endorsement, one that was a certified copy, whatever that means, with endorsement version 1, and then there was another so-called original note with endorsement version 2, correct?
Correct, Your Honor. And also in this case, you might recall that we mentioned in the brief, there was an expert testimony. The MADLs had an expert testimony witness that day, testifying to the signatures on affidavits that were filed in the case by the bank and also on an assignment of mortgage that the bank relied on at trial. And he testified that the signer on there, Jeffrey Stevens, which again was the guy that was involved in the initial robo-signing scandal with GMAC, who was the plaintiff in this case, or the servicer in this case, testified that the signatures on the assignment of mortgage and on the affidavits did not match. There was no testimony as to which one of those signatures, if any of them, were in fact Jeffrey Stevens, but there was no, I think based on the testimony that at least one of those documents was forgery, I think it calls into question all the documents submitted by the court, or by the bank in this case, and again going towards the re-endorsement of a note, which is perplexing that anyone would think that you can re-endorse a copy of the note to somehow to show your lost note count. You don't.
On your standing issue, the testimony from Wells Fargo's own expert, own witness and only witness, was that from all the documents he reviewed, neither Wells Fargo nor GMAC had the original note from somewhere around 2007 until April of 2014. Is that correct?
That is correct.
And there was no document to refute that fact for that time period, correct?
That's correct, Your Honor.
Before that, there was some kind of a comment that perhaps you could read that GMC may have gotten the note and then sent it to its counsel, but that would have been in 2006?
Correct. I know that the testimony that you're referring to was 4 or 5 pages long, and I wasn't trial counsel, but trial counsel did, I think, a fantastic job going through the comments log. Just as a side, these comments log sometimes are very hard to read, and this one particular was difficult to read. So it took some time to go through it with the witness, but the witness in that case agreed that they were, in fact, I think GMAC and their attorneys were searching for this note as early as 2007, and they did not get the note until 2014.
What's the effect, if any, of the assignment from MERS to Wells Fargo in 06, which assigned the mortgage, and then it says together with a note?
I don't think it has really any effect on the case before us today. And the reason why, I mean, there's a lot of reasons why I would say it doesn't have effect, but I refer this court to the Rodriguez case out of the 4th TCA, and I apologize, I left my notebook over there with the citation. But there's a Rodriguez case that goes in pretty good detail about what it takes to establish standing as a holder in a case. And it sort of highlights that there has been some courts have not been quite articulate as they could be in saying what holder status requires and conflating holder with non-holder. Essentially what the Rodriguez court held and going through the ECC was that in order to be a holder of a note, you obviously have to have possession of the note. What they in fact said was there's 2 core elements. One, who is in possession of the note, and who is the note endorsed to? Is it endorsed to the person in possession, or is it endorsed in blank? In order to have status as a holder of a note, which is what was pled in this case, not non-holder status, but holder status. In order to have holder status, you have to have both possession of the note and it must be endorsed to you or endorsed in blank.
So if a note has been lost, is it your contention then you can't be a holder?
I don't think you can be both at the same time. That's a perplexing question. I've kind of gone through my mind. I don't think you can be a holder. You can be a person with the rights of a holder, but you're not an actual holder if you're not in possession of the note. And going back to address your question about the assignment, why I say it's irrelevant, an assignment of mortgage isn't irrelevant to establish standing in a particular case, but that can only establish standing as a non-holder in possession. The way an assignment of mortgage comes into play under that context is if I'm in possession of a note and it's endorsed to another party, for example, so I'm not the one that's endorsed to, I cannot be a holder of that note. But if the person gives me an assignment of mortgage, the actual holder, the person entitled to enforce it, gives me an assignment, I now am a non-holder in possession of it with the rights of a holder. And that's important because those are 2 separate elements or 2 separate grounds for standings under the statute. They didn't plead non-holder status, they pled holder status. And the Rodriguez case makes clear that an assignment of mortgage is irrelevant when it comes to status as a holder. You must have possession of the note and it must be endorsed to you, and that didn't happen in this case. So to answer your question, I know it's a long answer, but the assignment of a mortgage is irrelevant in this case. That assignment of mortgage is irrelevant when it comes to proving holder status. And what's also interesting in this case is, going back to what Your Honor said, the beginning of this case, the note that they attached to the complaint didn't contain this endorsement. They admitted they didn't have possession of this note at the inception of this case. During discovery, they tried to pass off a copy of this note, and then later showed up at trial with another note and tried to use the excuse that the reason why they had to re-endorse the copy of the note is because they didn't have possession of the original. So I don't think there was any question that the time this case was filed back in 2009, they didn't have possession of this note. And even the second element we talked about, I think we just discussed the possession issue, is the endorsement. Suddenly it shows up at trial, they have an endorsement in blank. The question is, when was that endorsement put on the note? As this court and every other court in the state has said, is you having a blank endorsement on the note at the time of trial does not satisfy your standing. You must also show that the endorsement was placed on there prior to the foreclosure action being filed.
Hanfield testified that he had no idea when the endorsement was placed on the note, correct?
Absolutely had no idea, no record to show when it was placed on the note. So I think just based on those 2 things, they failed to show their standing in this case. They didn't show either core element for standing as a holder in possession. And I want to make that distinction. They pled holder, not non-holder status, so any evidence. So they didn't prove that case. The second issue we have on appeal here is paragraph 22 issue, which this court's probably heard ad nauseum. The witness for the bank in this case testified that the notice of default, and by the way, if you look at the notice of default, it doesn't look like what would ultimately be sent out to a homeowner, and the witness in this case for the bank actually testified this is not the original note. It's not even a copy of the original note. GMAC, who would have sent the note, didn't keep copies of the note. Or, I'm sorry, I keep saying of the notice. So we don't even really have an original of what was alleged to be sent out to the borrowers. And without that, without a genuine copy of the original, we can't tell what language was included in it if it ever was sent. But beyond that, the witness in this case said that it's not GMAC who was the servicer at the time, it was Aquin at the time of trial, that GMAC at that time, it was their policy to send these notices of default, the information over to a third-party vendor, and it was a third-party vendor who would send out those notices of default. What was quite clear from his testimony was that, and he stated very specifically on cross-examination, that they had no information, no record to show that that third-party vendor actually received default information from GMAC. They had absolutely no record to show that that third-party vendor generated a notice of default, and they had absolutely no record to show that that third-party vendor actually sent out that notice of default. That ends the case. Their own admissions that they have no evidence this was ever sent. So this case should have been dismissed based on those grounds alone. I see that I'm approaching my 10-minute time. I think I'll reserve the remainder. And
All right, counsel, thank you.
thank you, Your Honor.
Morning, sir.
May it please the court. David Ehrlich, blank Rome, on behalf of the appellee, Wells Fargo Bank as trustee, and we respectfully request that this court affirm the final judgment of foreclosure for the very simple reason that the final judgment is supported by competent substantial evidence for all elements to be proven to substantiate a final judgment of foreclosure, specifically standing, breach of the mortgage, satisfaction of a condition precedent, and damages.
Well, on the standing issue,
Sure.
your witness testified by his review of the records. Obviously, he had no personal knowledge of anything in terms of before he came to work. He testified that he reviewed all the records, and going through the comments notes, it was clear that neither GMAC nor Wells Fargo nor its two attorneys had the original note or could locate the original note between sometime in 2007 up until April of 2014. Is that correct?
Yes, but it's not dispositive, Judge.
Well, but if you're relying on possession of the note as the holder of the note, GMAC, Wells Fargo, nor its attorneys had the note between 2007 and 2014, and suit was filed in 2009, correct?
Yes, but Judge, just to be clear, the complaint pled owner and holder. And under the Marciano, this court's decision in Marciano, and as it's been adopted by the 4th District and Ballas, that the pooling and servicing agreement and the corresponding mortgage loan schedule.
The pooling and servicing agreement in Marciano and Bolus were executed pooling and service agreements. This was unexecuted. There was no signature on the one that y'all put in evidence, correct?
But yes, Your Honor, but
It's an unexecuted document, and the admissibility for it was because it was on the SEC's website.
But Your Honor, they have not challenged admissibility, if I may, they have not challenged the admissibility of any of the evidence that's in the record here. This is a.
You're saying they didn't raise hearsay objections to that particular document, that they didn't point out that it didn't have a seal on it?
I'm saying
that they pointed out it was not executed?
I'm not saying in the trial court level, Judge. I'm saying in the initial brief, they have not challenged the pooling and servicing agreement or the mortgage loan schedule. You will not find those words in the initial brief. And
You relied on that, though, for proof in your answer brief that you did, in fact, have the note.
yes, Judge.
And then they responded to that in their reply brief.
Yes.
So you put it at issue.
Well, to substantiate standing, to demonstrate that the judgment is
Exactly.
supported by competent and substantial evidence.
Right, and when you relied on the pooling and servicing agreement from the website that's unexecuted, they challenged that in the reply brief. So it's at issue, it's at play here. So how can you rely on an unexecuted document
Because it's,
that's authenticated because it's on a website on the internet?
the trial court found correctly that it does satisfy 90.202 subsection 8 for a public records document. And if the appellants wanted to introduce a contradictory copy, they had every right to. The case had been pending for
What's
7 years.
the evidentiary value of an unexecuted pooling and service agreement?
Because, Your Honor, it is a public document that had passed the SEC muster and it was publicly available.
If it had blue ribbons and gold seals, an unexecuted document proves it's an unexecuted document, correct?
No, not in this instance, Judge, because it satisfied the trial court and it satisfies 90.202 subsection 8. And again, they have not challenged.
Well, the trial court
I
would-
thought under that rule was a rule of authentication. And so if it's a public document and you get the right kind of seal, you can assume that it's an authentic document. So we can assume that this is an authentic, unexecuted copy, but what does that tell us?
Well, a couple more things, Judge. One, the business records exception for the document was also conveyed at the trial court level. So admissibility.
Business records exception was not met here, and the trial judge may think it was, but this document was not created by, is it Oswin? Is that how you pronounce this?
Ocwen.
Ocwen. It was not created by Ocwen. Ocwen got a copy of it off the internet.
But
Then thereafter, they kept it in their file. So they have no idea who created it. They were not the authors of the document.
there's no argument made by any party that the execution is somehow dispositive of it. The fact is that under the trial judge admitted it into evidence, they did not raise it in their initial brief. Your Honor is correct that we are relying on it in our answer brief. But Judge, if I may, there's three grounds for standing. It's not just the pooling and servicing agreement and the corresponding mortgage loan schedule because of this
Well,
court's
let's talk about the
decision.
mortgage loan schedule. That was not attached to the SEC copy of the PSA.
That's
It was
correct.
referenced in there.
Yeah.
And your argument below for admitting that into evidence, well, if this unsigned, unexecuted document without a seal on it, it refers to it, therefore this document now is automatically admissible.
But Judge, the mortgage loan schedule, the business records exception was specifically laid for this because it is not a public document. So the under 90.803 sub 6, at the trial court level, the business records exception was laid and properly admitted by the court. So once that's in evidence and it's not challenged for its admissibility, it is it's in the record, it's before this court. That mortgage loan schedule specifically placed the subject loan in the trust long prior to this lawsuit being filed. So again,
But it did not prove that it was endorsed at that time.
based on section 2.01 and this court's decision in Marciano as it's been adopted in Ballas and in Ashby by the first district.
With
that
executed pooling service agreements.
I don't believe that they specify that specifically, Judge.
Nobody-
And I just happen to know in Ashby because I was appellate counsel in that case, that similarly was not an executed copy.
And it was not, it was either not contested.
Oh,
No, I'm talking about, in one of those two cases, it really wasn't contested.
that's a fair assessment, Judge, but nothing changes that this is a public document that passed the trial court's standard for whether it's admissible under 90.202 sub 8. And once it's in and not challenged, it is before this court, and it is a document that signifies ownership. And that's the one thing I wanted to point out to this court, that the MADL's entire case has been predicated on holder, holder, holder. And the complaint pled owner and holder. And in Ballas, the court, in evaluating the pooling and servicing agreement and the mortgage loan schedule, found that it satisfied the owner or holder standard, which is as the complaint is pled. And so even if all of the arguments about possession and all of their arguments are somehow meritorious, that doesn't change the fact that there is undisputed evidence that the appellee owned this loan back in 2005, long before this lawsuit was filed. There's not a single case in Florida where a trial court and an appellate court found that ownership did not substantiate the judgment. There are cases where they found where they did not prove ownership, but proved holder that wasn't.
And the proof of ownership is actually through the PSA?
That's part of it, Judge.
What's the other thing?
The assignment of mortgage that specifically references the note and the mortgage, and that has been recognized in Florida courts as a proper assignment of the note, is the language that's been used in a case called Lakem and other cases where that has been sufficient to demonstrate ownership. Also, Judge, that fact that the note was found in the GMA's comment log under Exhibit 7 of the appellee's case in chief, that there's a comment log that does reflect that that GMAC did possess the note in 2006, and so that also predates the filing of the subject lawsuit. So, as much as the court can focus on the MADL's arguments about holder status, the fact is that there's uncontroverted evidence that, and competent and substantial evidence specifically, that Wells Fargo owned the loan. There's no contrary evidence. The word ownership barely appears. In fact, the MADL's briefing completely glosses over the fact that the complaint pled owner and holder, owner and or holder. It's paragraph 6 of the operative complaint at the time of trial. And there's no controverted evidence of that. And in this situation,
There's 3 grounds. The one was the PSA,
Sure.
the other was the assignment, and what's your third?
is the note endorsed in blank.
You have no idea when that note was endorsed in blank.
And again, Judge, we'll go back to the pooling and servicing agreement and the mortgage loan schedule, which I do represent to the court, is in the record and unchallenged in terms of its admissibility.
The pooling and service agreement, the terms, the articles, whatever under that would have said it should have been endorsed.
Well,
It doesn't mean it, I mean, it's not direct proof that it was endorsed.
Well, Your Honor, under this court's decision in Marciano and in Ballas, it is in fact evidence that it was endorsed, because under the specific language of 2.01, and I'll point, Your Honor, to page 839 of the record, it specifies that in order for a loan to be placed into a trust prior to closing, there must be an independent confirmation that it is endorsed in blank. And on page 110 through about 116 of the transcript, the appellee's witness testified in intricate detail both on direct and voir dire and cross-examination about the inner workings of the pooling and servicing agreement. And that's why this case is on all fours with Marciano. The facts are fundamentally indistinguishable from Marciano, this court's decision. And even more so in Ballas, which was the 4th District's adoption of Marciano, where there's no evidence that the mortgagee ever had possession of the note. In fact, in both this court's decision in Marciano and in Ballas, the central issue is that the appellee couldn't substantiate physical possession at the time the lawsuit was filed. This court in Marciano and in the 4th District in Ballas and in the 1st District in Ashby, they all found that the pooling and servicing agreement with the mortgage loan schedule attached to it is evidence that the mortgagee owned or held the note. And specifically, I'll harp on the language in Ballas because they say owned or held the note. And that's what we have here, Judge. There's no...
Familiar with, I think it's Friedel versus Bank of New York
Absolutely,
Mellon?
Judge.
And how do you distinguish that case from here?
Very succinctly and very directly, Judge. I'll point you to footnote 1 of that case. In Friedel, there was the bank's witness. Specifically, they found that had no knowledge of the inner workings of the pooling and servicing agreement, the mortgage loan schedule, or just basically how it worked. It was just a poor witness presentation. In contrast, in the present case, I'll point Your Honor to page around 110 to around 117 of the transcript. Mr. Hanville testified with great clarity and great directness about the inner workings, what a depositor is, who the trustee is, how a trust closes, what is required in order for a trust to close, and that's where we get into evidence under Ballas, that evidence that the note was endorsed in blank prior to the trust closing, and the fact that the mortgage loan schedule, which passed into evidence under the business records exception and places the MADL's loan squarely in the trust, is evidence that the Wells Fargo owned the loan at all times relevant.
Let's talk about paragraph 22 for a minute.
Sure.
What actual evidence is there that GMAC batched the information to Pitney Bowes, that Pitney Bowes created the letter, and that the letter was actually mailed to the borrowers? Sure.
Judge, under Florida Statute 90.406, the GMAC's business habit evidence that it was part of their regular business practice to submit this information, and they actually create the letter. It's a misnomer to say that it's created by a vendor or any of that. It's created by the servicer, and Mr. Hanville testified quite eloquently and with specificity of how that works. The servicer for the mortgagee enters that information into a platform, and that makes it their record. Okay, and so under 90.406, that is business habit evidence that that's how it works. And even further, Judge, and this is why
It proves the document was created. I'm not sure anybody's really contesting whether or not GMAC created the data.
Okay.
My question was, I thought Mr. Hanville testified that he had no document that showed GMAC actually batched that data to, actually that it was received by Pitney Bowes.
That's not, respectfully judged, that's not accurate. If I point your honor to Exhibit 7 of the record, I can try to find a pin site in the record, but I know it's Exhibit 7. It's somewhere in the 11s. That there's a comment log section of GMAC's comment log where they have a specific notation that it was sent and that it says breach letter, and the comment D19 next to the comment, Mr. Hanville testified that
GMAC wouldn't have any idea whether it was sent. It wasn't sent by GMAC.
but it was GMAC's business records to confirm it was sent before making that notation. And that is
That
business
it
habit
was sent.
evidence.
When you say it, the data was sent to Pitney Bowes or that the letter was sent?
Both. That process had been completed. That,
How would GMAC know if the letter was sent when Pitney Bowes is the one sending the letter?
because it was their business practice to confirm that before making the notation. That is business habit evidence, Your Honor. The defense bar has attempted to stretch that requirement further than any other condition proceeding has been stretched in Florida.
Help me understand, I agree with you that you can certainly prove routine business practice. So the routine business practice here is we, GMAC, produce this information and send it over to Pitney Bowes. What information was there as to the normal practice of what Pitney Bowes does with it once they get the information? If we assume that it was sent, and let's assume that Pitney Bowes received it, how do we know that Pitney Bowes then actually sent it as opposed to throwing it in the trash?
Because it was part of GMAC's business practice to make that confirmation before they enter that notation in the comment log that does appear in this case. And again, it goes back to business habit evidence. The defense bar would have mortgagees.
Was it their business practice to lose a note for however many years, 7 years?
Not ideally, Judge, certainly, but again, there's no question that they owned it.
Mr. Hanville testified, is there anything that confirms the transmission was successful to the third-party vendor? I don't have any way to determine that. And I'm looking at page 82 of the transcript, 1421 of the record, because I don't have any way to determine that. Isn't it true you have no record to confirm that this third-party vendor actually created a breach letter? I don't have possession of such a record. Isn't it true there's nothing that confirms the third-party vendor actually mailed out the breach letter? His answer was, I don't have such records. And what is there here that confirms the third-party vendor actually mailed out that breach letter? Nothing I have here confirms that. I mean, that's your witness testifying based on his review of the records. And he said even as far as the business practice, he didn't learn that from review of a business record. He asked people who used to work at GMC, which is kind of the classic hearsay. How did you guys do it? I heard him say, here's how they did it.
A couple points, Judge, because there's a lot there. First, it's not hearsay because they didn't raise that in their briefing. Perhaps that was an argument made at trial. It's not raised on appeal. And second, again, the business practice that GMAC made the confirmation before making that notation, directly in the transcript, Mr. Hanville does testify that it was sent.
Which page is that?
102, transcript 102, 14, that it was sent to the borrower. And so
is that based upon, the confirmation of that was the D19?
Yes, well, that's part of it, Judge. Again, that goes to the GMAC's business practice. And I would like to point out this court's decisions in Gorel and Vasilevsky, which I think, I think they are squarely brought within this case because Gorel and Vasilevsky required prejudice.
They require substantial compliance, and if you've got substantial compliance, then prejudice. The question here is, have you demonstrated substantial compliance? Nobody's quibbling about the language of the letter. The issue is whether there's adequate proof that the letter was actually sent.
Well, 2 points, Judge. On the one hand, Wells Fargo does have record testimony that it was sent through Mr. Hanville. The oral testimony should suffice. Also, the habit evidence under 90.406 that GMAC confirmed this before making this notation. And second, Judge, your opinion in Gorell for Wells Fargo believes that that should not be limited to the narrow situations where there's substantial compliance or some technical deficiency. The spirit of your opinion, and even as Westlaw has the head note actually, is that it's not limited to when there's substantial compliance. It's just simply that a borrower must demonstrate prejudice when making a argument that the mortgagee has failed to satisfy a condition precedent. And this
Apparently Westlaw gives me a lot more spirit than I intended.
well, for what it's worth, Judge, I think this case it demonstrates why. There's no evidence that the MADLs ever attempted or wanted to bring the loan current, and that was not part of the presentation. And ultimately,
All right, counsel, you've exhausted your time.
thank you, Your Honor.
Thank you so much. You agree with everything he just said, right?
100%. Just kidding, for the record.
So is he.
Was there any questions you want to ask before I did my rebuttal? I'm going to start off with some of the argument on standing in the PSA, and sort of touching on your argument that this wasn't executed, so it really doesn't mean anything. And whether you view it as a matter of admissibility or just weight of evidence. I mean, an unexecuted document, even if it's admitted and admissible, doesn't really establish anything in this case.
Does it establish anything other than it's an authentic copy of an unexecuted document?
I would say
What weight
that.
are we supposed to give to an unexecuted document?
I'm sorry?
What weight should we give? Let's assume it's an authentic copy, but what weight do we give to a document that's not executed and apparently doesn't have the mortgage loan schedule attached?
0, because, the document itself has certain acknowledgments. Those acknowledgments are purported acknowledgments by the the signer of the document. Since no one signed it, those acknowledgments mean 0. And I think, again, I don't want to harp on the context of the robo-signing scandal, but everything else happened in this case. I would have a hard time giving weight to anything that was admitted by the bank in this case. And it's not a disparaging counsel here today. They weren't responsible for that. But I don't think it provides anything. But another point to make on that, you mentioned the Friedel case down in the 4th TCA, and their initial opinion was withdrawn and entered a new opinion. But the original opinion in that case actually had some really good points to make on a PSA exactly like this, and it sort of distinguishes this case from Marciano, even if you were going to consider that PSA. What Marciano looked at was provision 1.01 of the PSA in that case, which correlates to 2.01 in this case. What it looked at was the language in there that says that the plaintiff is acknowledging receipt of the note and document, or the note and mortgage endorsements and everything else. What the original Friedel case pointed out in this court, and I think you can see in this case, is there's a section 2.02 right after that. In section 2.02, if I may grab my laptop really quick, briefly what I'll tell you is that makes that first provision, 1.01, conditional. What it says in there is that once receiving, or that the bank will issue what's called an initial certification after it reviews the records that it receives into the trust to make sure everything is actually there. And it's not actually confirming anything is in there until they do this initial certification. And attached to the PSA is a form that that Wells Fargo would use to verify that they have in fact received these documents, and they can also describe if there's any inconsistencies or any problems with the documents they received. Well, there is no initial certification entered in this case. And there's also, under the same provision, there'll be a final certification that says, yes, we have everything, we're good to go, we have everything. And if something's missing, they can go back and try to get those documents. So 1.01, although it says there's an acknowledgement, it is conditioned upon whoever receives those documents to enter an initial certification saying, yes, we have received it. So even if you were to see this PSA as somehow relevant in this case or establishing anything, that language is still conditional. I think that distinguishes it from the Marciano case, because the Marciano case did not discuss that particular language that I'm referring to in 2.02 here. And in the Marciano case, you did note that you were the only court to come up with this decision on the PSA, and that you were relying on the specific language of the PSA before the court at that time, and that's how you made your opinion. By looking at the specific PSA in this case, it is clear that until they issue initial certification, there is no acknowledgement that they had possession of the note endorsed in blank. And then when you couple that, even if, let's get past that point just for a second, even if they had some kind of evidence, even to forget the lack of signature on the PSA, forget Section 2.02, even if they established that they had possession of this note back in 2005 when this loan closed, we have clear testimony here from the bank that as of the time they filed this case, they didn't have it anymore. And they were so sure they didn't have it, they actually re-endorsed a blank copy of a note. So and they filed a lost note count. So there's no doubt that they didn't have possession of this note at the time the case was filed. I think their own testimony established that. Counsel mentioned that they don't have to prove holder; they can only prove ownership. There's no law for that. The UCC gives you 4 examples or four ways to establish standing to enforce a note. You have holder, you have non-holder, you have a lost note count where if you've lost it, you can establish a lost note. And there's a 4th one that's rarely ever, I've never seen it, where someone, I think, accidentally pays a note on behalf of someone else. They can step in, but it's a wrongfully paid note in some way. It doesn't say that you can establish standing as an owner. It says that you don't have to be an owner, but it doesn't say ownership is enough. You have to either be a holder, a non-holder, or establish a lost note. They didn't establish, they alleged holder, they didn't establish holder, nor did they establish any elements for a lost note for that matter. So I think their standing fails as a matter of law. I want to mention also paragraph 22. There's a few points I want to rebut. They made a reference to the comments log. I think it was January 5th of 2009, and all it really says in there is breach Melissa MADL. And that's what they're relying on to say, yes, we sent this notice of default. If you read the context of that testimony where he says sent the notice, it's clear, and I think even they make this argument in their answer brief, the context is that just shows that they sent this over to Pitney Bowes. But when you look at the further testimony where it testified directly, as you cited, they have no record that Pitney Bowes ever generated this letter and sent it to anybody. And as far as routine business practices, they didn't produce any evidence or testimony regarding Pitney Bowes' routine practices, so I think that's a non-starter. But even if we give them all the benefit of the doubts on business practices and that they sent this letter, this court has already said using the language sent isn't enough. To say you sent a notice, paragraph 15, if I back up for a second, paragraph 15 of the mortgage establishes how these notices must be sent to the borrower and how these notices are given to the borrower. Paragraph 15 states that a notice is not deemed to be given, and these are the language of paragraph 15, is not deemed to be given until it's mailed to the borrower. If it's mailed by first-class mail, it's deemed to be given when they mail it. If sent by any other means other than first-class mail, it is not deemed given until actually delivered to the borrower. And based on that reasoning, this court on multiple occasions, one case was Martins v. PNC Bank, which was a summary judgment case, held the affidavit in that case that the bank was relying on for summary judgment stated that they served the borrower or they sent the notice to the borrower. And this court specifically said that language is not enough because it is not established that they mailed it by first-class mail or actually delivered.
Did your client testify that he did not receive?
He absolutely did, Your Honor. I can go specifically, but he testified that he has a separate filing cabinet at his house and a separate folder that he keeps for these notices and or all communications from the bank, and that he keeps every communication he receives from the bank, that he went through that folder and couldn't find anything remotely resembling a notice of default, and that he never recall ever receiving the default. And that was unrebutted testimony, unobjected to, if I recall. And so you have evidence in front of this court that there is no evidence that it was mailed by first-class mail, and there is no evidence that he actually received it. So it doesn't satisfy paragraph 15, even if we accept the terms that they sent the mortgage. And I want to refer to this case, or sent the notice of default. I also want to refer, I cited to Martins v. PNC Bank, also the Figueroa case, Figueroa versus Federal National Mortgage, has some good language. And in there, they didn't admit a copy. They didn't admit a copy of the notice of default that was sent, and I would submit that that's pretty much what we have here. Although they entered something purporting to be a notice of default, they admit it's not an original copy. It's not a copy of the original. But beyond that, it said further, and this goes to the paragraph 15 issue of requiring to show that it went by first-class mail or actually delivered. Anderson could not confirm that the default letter was mailed via first-class mail. Additionally, Anderson had no knowledge as to whether the appellant actually received the default letter. Accordingly, Fannie Mae failed to prove compliance with that condition precedent, and this court required dismissal of the case. It didn't require a showing of prejudice, and your honors are very familiar with the law on prejudice. It doesn't apply in this case. And as I pointed out in the brief, past times when the client has received these notices, they've actually paid the default $30,000 and $40,000 amounts, so it's significant. And there's no indication here that my clients would have done anything differently. Another point I want to make on this is, you know, I know it doesn't need to be said, but I would feel remiss by not saying it. This isn't a case where my clients are looking for a free house, nor will they get a free house. All they really want to do, and they've wanted to do this whole time, is to pay their mortgage. If this court was to dismiss this case, which is what I think it should do, my client doesn't get this free home. They still have to make their mortgage payments. The bank's going to get their payments. My client's going to get their home. And that's all we're asking for in this case.
All right, counsel, thank you so much. That concludes our arguments for today, and we'll be in recess.